Hi guys, welcome back to Battle with Ola. This is Mujala Olua and I'm super thrilled to be here once again. Today we want to talk about the burden of proof and the standard of proof. So it's going to be a short video. Make sure you watch till the end, like the video and leave me comments in the comment section. What do we mean by burden of proof? It in Latin means onus probandi, and it's from a Latin maxim that essentially says in English that he who asserts must prove. Essentially, the court is saying that when you come to court and claim something, or you want to claim something from the court, or you're claiming that someone has done something to you, you must prove sufficiently to the court that what you're saying is correct, what you're saying is right. So the onus, that's the burden of proving that, is on you, not on the other party. That's why you find that in some cases or instances where a matter can proceed, when the respondent or the defendant does not answer the court will insist that the person that has come to court, the claimant, the plaintiff, must proceed on the strength of their own case, not on the weakness or the absence of the defendant. That is, they must lead evidence still, especially in property litigation. Even if the defendant does not show up, you must lead evidence to prove to the court that you are the rightful owner of the property and the claims that you're making is valid and is correct. So, burden of proof is the load, the responsibility, the duty that the court lays on a claimant to prove their case. Now, standard of proof is different. Standard of proof is the level of certainty or persuasion that is required by law, by the courts, for the burden of proof that is on the claimant or on either party to be discharged. So essentially, standard is how far the burden of proof must be discharged or must be exercised before the court can hold for a party claiming before it. So essentially, let me make an analogy. I hope it's correct. So let's say that you're a student. The burden is upon you to pass so that you can graduate. That's the burden of proof, so to speak. Now, the standard of proof, maybe we could say that for you to graduate with a first class, you have to score a 70 and above. That's the standard. But the burden is that you must necessarily pass. But if you now want a first class grade, you must pass, not just pass, you must dispense the burden of passing to a very reasonable extent, to a certain standard, before the court will agree with you. So that's essentially the difference. To discharge the burden of proof, a claimant before the court can call witnesses to give oral evidence, or they can tender documentary evidence. Now, burden of proof is not only on the plaintiff or the claimant in a matter, it is on whoever is claiming. So for instance, if a claimant comes and says that, oh, this company is owing me so and so, there's a burden laid on them once they owe. Now, if the defendant also comes, even though they are the defendant, but they are saying that we are not owing you, as a matter of fact, this is what is happening. Or if perhaps they're also counter-claiming something else, they also have a burden to prove their position. So when we say claimants, we are not necessarily limiting it to the person that files a lawsuit. We're saying that in both cases, and it also applies to criminal matters, where the state has brought someone to court and said that this person is an armed robber, this person is a thief, this person is a murderer, this person is this or that, there's a burden on the state to prove that that is who they really are. And there's a burden on the defendant too, to also prove that they are not that, or to disprove what the state is saying. But in general terms, the burden is on the person that comes to court. So, but the person they have brought can also disprove their case. So burden is a duty. Now, standard is the extent to which that duty must be fulfilled. I think that should clear it up. Burden is a duty, a responsibility, something that someone must do once they claim or assert a position. Now, the standard is the extent to which they should carry it out before the court will agree with them and hold for them and say that, oh, it is true, it is certain. Now, in a criminal matter, the standard of proof is beyond reasonable doubt. That means that the prosecution, the party that brings someone to court now, on a suspicion of having committed a crime, they must prove to the court that beyond reasonable doubt, this person actually committed it. Now, reasonable doubt has been held to be not absolute doubt, but a reasonable man's doubt. That is, any reasonable man that would judge the case on the basis of the evidence that the prosecution will lead, whether oral evidence, whether documentary evidence. Such reasonable person will be able to decide the way that the court will decide in that matter, or the court will be able to decide in the way that any reasonable person will decide. So in criminal matters, the duty is to fulfill the burden is beyond reasonable doubt. So in criminal matters, the burden of proof must be discharged by the prosecution, and the standard to which they must discharge it is beyond reasonable doubt. But in civil matters, it is on a preponderance of evidence. That means on a balance of probabilities. That means that when a person claims something before the court in a civil lawsuit, which is also a civil matter, the other person too will come and disprove their claim. So both of them will adduce evidence before the court. The court will believe the person that is most convincing. That's essentially what that means, on a preponderance of evidence. So the court will weigh. It's like you can draw an imaginary scale in your mind. So if Mr. A says, I'm the owner of the land, these are the title documents, the court will drop it on Mr. A's side of the scale. You know, the scale will come down, and this person's scale will go up. That's the defendant. And you know that the person that weighs more on the scale is the winner. Now, this person too will now come and bring maybe C of O of better documents and say that I got this one from the government. I'm the owner of the land. This land has been in my family for 50 years. And this is how it has passed and passed and passed and passed and passed. These are my boundary men. They have always known us to be the owner of the land in our family. This is that, that is this. Now, the court will take that evidence too and drop it on the scale. And then it will come down. As it comes down, this one will go up because it's becoming lightweighted, you know, in when compared to this one. So it will go down. So the court will continue to take evidence from both parties, documentary evidence, oral evidence, you know, go down, go up, go down, go up. So eventually, at the end of the matter, when parties file their final written address and the judge reads it, and then it takes it alongside all the evidence that was led in the matter, the person on the scale who goes down, that is who weighs more, will win the case. That's how it is in civil matters, on a preponderance of evidence, on a balance of probabilities. That is, how probable is it that whose case is the most probable that this is probably the truth. This is probably what happened in this matter. Whose case is the most probable? That's the person that the courts will believe and hold for in civil matters. So the standard of proof in civil matters is on a preponderance of evidence, on a balance of probabilities. But in criminal matters, the prosecution must prove their case beyond reasonable doubts. And that is why the duty of any good or smart or sound defendant or defense team is to sow doubts into the prosecution's case. Make the court disbelieve the prosecution. That is your duty as defense counsel or defense in a criminal matter. And prosecution's duty is to make the court believe and agree with them. You know, that is, how will any reasonable person decide? That's the standard of proof. I hope that you understand this. Burden of proof is the duty that is on any party asking anything from the court to lead evidence sufficiently, you know, before the court, to get the court to agree with them. Standard of proof is how far, you know, they must lead evidence before the court will agree with them and hold in their favor. That's all I have for you in this video. I'll see you in my very next video. Don't forget to subscribe, make a friend along to battle with Allah. Toodles!